are starting to run out of time for this exam prep. So I'm going to fly through note cards in no particular order. Starting with frolic versus a detour. A frolic is more than a slight deviation from the employer's purposes for which the employer is not responsible for the employee's negligent conduct. However, a detour is only a slight deviation from the employer's purposes for conveniences of employees for which the employer is responsible for the employee's negligent conduct. A slight deviation is generally personal acts that are not far removed in time, distance, or purpose from the employment are deemed to be incidental. Joint venture and joint enterprise. From the Restatement of Tort, Section 491. These are synonymous, whether you call it a venture or an enterprise. A venture where there is an agreement, expressed or implied, among members of a group to act with a common purpose to enhance their pecuniary interests, in which they each have equal control over the direction of the enterprise. So the agreement is expressed or implied among members of a group. They have a common purpose to be carried out. There is a sense of community, a pecuniary interest among the members of the group. And the members of the group all have an equal right to a voice in the direction of the enterprise, which gives equal right of control. Okay. Strict liability from the Restatement, Section 519 reads, a person is strictly liable for any harm which occurs while engaging in an abnormally dangerous activity, so long as the harm results from the kind of risk that made the activity abnormally dangerous. Safety precautions taken by the defendant are no defense in strict liability. Furthermore, from another angle, wild animals belonging to the defendant will impute strict liability on the defendant if they should cause the plaintiff harm. And that would be wild animals that are not natural to the area in which they're being kept by the defendant. Domestic animals, on the other hand, will not necessarily impute strict liability on its owner unless the owner has knowledge that they have dangerous propensities. Strict product liability is for strict product liability, joint and several liability should be used, not comparative negligence, because these it relates to indivisible responsibilities. Now, strict product liability coming from the Restatement, what I read earlier is about its procedural applicability, but from the Restatement, Section 402A, strict product liability involves one who sells any product in a defective condition, unreasonably dangerous to the user or to his property if A, the seller is engaged in the business of selling the product, and B, is expected to and does reach the user without substantial change in its condition. And the rule applies even though the seller used all possible care, and the rule still applies if the user is not privy to a contract with the seller. A joinder element, beautiful nails. joinder element will only join joint tortfeasors that acted in concert. The plaintiff cannot be compelled or forced to enjoin any other parties, like co-defendants, without filing a cross-claim. Rule 14a, Federal Rules of Civil Procedure, under which the defendant may bring into the cause of action another person who may be liable to him for all or any part of the damages, even though the plaintiff has not sought a judgment against him. Substantial factor test in joint and several liability. So, when two factors combine to cause damage, and either alone were sufficient to cause damage, both responsible parties are liable as long as each were a substantial factor causing the damage. Additionally, if the injury was the result of one tortfeasor, the burden shifts to each defendant to prove his negligence was not the cause. If no defendant can meet his burden of proof, then both defendants are liable. And that's from the Summers versus Tice case, where both defendants were negligently shooting towards the plaintiff, and only one of them hit him, but they could not determine who. To hold any different would exonerate both from liability, even though both were negligent. I never did find out what a superseding cause is from the book, but it is not the same thing as an intervening cause. I do think that a superseding cause can be vis major, which is like an act of God. So I'll just write that as an example. VIS major is like an act of God. An intervening cause is acts of a third person intervene between the defendant's conduct and injury. The causal connection is not automatically severed, though. So when that occurs, the causal connection is not automatically severed. Liability turns upon whether the intervening act is a normal or foreseeable consequence of the situation created by the defendant's negligence. If the intervening act is extraordinary under the circumstances and not foreseeable in the normal course of events, or a superseding act which breaks the cause nexus. So again, liability. So sometimes a third party or third person, or even in some other event, can intervene between the defendant's conduct and the injury, and this doesn't necessarily break the causal connection. The liability turns upon whether the intervening act is a normal or foreseeable consequence of the situation created by the defendant's negligence. If the intervening act is extraordinary under the circumstances, not foreseeable in the normal course of events, or a superseding act which breaks the causal nexus. So if we're talking negligence, I'm not sure if this is, let's just call it negligence. I hit another car and the driver needs to be rushed to the hospital, but as the ambulance arrives and he's going to the hospital, it would be one thing if somebody on the ambulance did a bad job. That would be something likely foreseeable, but it would be quite another if, while he's being put into the ambulance, he's struck by lightning. I feel like that might be a superseding cause, but it could be that he's hit by another vehicle while he's being transported from his car to the ambulance. that might be one that breaks the causal connection between the original injury. But we've seen in some other cases that there's different types of causes. In concurrent causes and are not intervening causes is taken from a similar case, but contemporaneous causes are also not intervening causes. So I don't have an analysis of like either of those, and I don't expect to be using that terminology in one of the fact patterns in the final. But it does exist and be good to look into. So instead of a cause of action, this is the discovery rule, not the definition of discovery, which I would like to know, but instead of a cause of action accruing from the time of injury, the discovery rule allows tolling, which is a stopping of the statute of limitations until the plaintiff gains sufficient knowledge of facts that would put a reasonable person on notice of a problem with, in most cases, a surgery that took place. But, the injury perhaps was a car accident that he didn't notice he had, sustained an injury, and didn't go to the hospital. But, a week later when he's having, like, whiplash symptoms, and that's a week later, but saying it was, 2 years later is kind of stretch, but in that particular fact pattern. But it's something along those lines. I guess a real case would be a lady gets a procedure to prevent her from becoming pregnant, and then over a year later, which is beyond the statutes of limitations, she gets pregnant and has complications, which is why she undertook the procedure to begin with. And now that she is aware of the unsuccessfulness of the procedure that she went through, she wants to bring a cause of action. However, it's after the statutes of limitations, and so that jurisdiction decided in that case that they were going to adopt the discovery rule, which allows tolling of the statute of limitations until the plaintiff gained sufficient knowledge of facts that would put a reasonable person on notice of a problem or of the injury. The self-help rule precludes a condition that one should have known from worsening into another condition. So, an example of this. Well, let's go with a different application of the self-help rule is the landowner has the right to cut down tree branches and roots intruding onto his property from adjoining property. That's a completely different take on it than the malpractice take on it that I was providing earlier. So it's kind of like the defendant that had whiplash. He didn't go to the hospital and finds out later. Well, he didn't take those actions to help himself. So the self-help rule might activate here to prevent or to at least alleviate some of the responsibility of the defendant for the injury if it worsened into another condition because of the plaintiff's own negligence. Assumption of risk principles is a defense for the defendant. It requires that the plaintiff had actual knowledge of the risk, that the plaintiff had an appreciation of the magnitude of the risk, and that the plaintiff voluntarily encountered the risk. Now, to voluntarily encounter the risk, the plaintiff must have had a choice absent of alternate options. And if the plaintiff protested, then that negates this element, that the plaintiff voluntarily encountered the risk. So if the plaintiff said, I don't want to use the outhouse, I want a bathroom in my unit that I am paying you for, and falls through the floor when she's using the outhouse because she has no other option, you cannot say that she voluntarily encountered the risk, not just because there weren't any other options, but also because she made a protest against it. So exculpatory clauses are like hold harmless agreements. Pre-injury release forms are an express form of assumption of risk. For an exculpatory clause to be upheld in a court of law, it has to comport to certain principles of fairness, and it can't violate public policy. So for that to be the case, there's a couple elements that need to be present. One, it needs to be unambiguous. The courts like to see it say the word negligence in it. And negligence must be within the scope of the agreement. So it shouldn't necessarily say that there's no liability at all for being, in my building. It'll probably be like, you're going to hold us harmless if you are injured using, workout, fitness equipment in this building. However, if this building, combusts and our doors are broken so you cannot escape, then, that's a different type of negligence that isn't what you probably first thought when you signed that pre-injury release form. And you also need to have equal bargaining power. So the gym that's giving you the pre-injury release form has the benefit of being incorporated, having, a legal team, whereas you, the person who's signing it, are not in equal bargaining arrangement, but you can't be in a really vastly, it can't be under duress, or just be this is a way that this is proven is if it's it wouldn't be a gym membership. It would be this is the only power company that serves this town, and you're asking me to sign an exculpatory clause saying that I'm going to hold you harmless for any and every possible thing that could happen, which just doesn't seem fair, because of the utility that company provides, being one of necessity. So satisfaction, our next note card, is an acceptance of full compensation for the injury. One who was injured by the wrong of several parties may recover damages against either or all, but although there may be several suits and recoveries, there can be but one satisfaction. The reason of the rule is that while there may be many perpetrators of a wrongful act, each of whom is separately liable, yet the act and its consequences are indivisible, and the injured person is therefore limited to a single satisfaction. So, yeah, so my car is totaled. That's one indivisible, damage incurred by me. It's not like my car and my house are both completely, totaled and, and I need like a hotel because my house is, unless if your car was in your garage and it exploded and your house went with it, would you bring one action? Maybe. But usually damages are not like divisible. They usually have unity. So that is why the satisfaction is full compensation for one injury. However, you can be collecting it from several perpetrators. So a release is not a satisfaction. It is a surrender of the plaintiff's claim. The clause may hold that the release of one tortfeasor releases others who may have liability. Contribution among joint tortfeasors is usually applied on a per capita basis or a comparative fault basis. Contribution is partial reimbursement available to defendants who pay greater than their share of the fault for the damage, and the defendant may bring into an action another who may be liable to him for all or any part of the damages except for willful misconduct. A defendant can't collect contribution from a tortfeasor that is immune to the plaintiff. So if you're talking an accident where like 6 parties are involved and one of those parties is the spouse of the plaintiff, then only 5 the damages are going to be split between 5 parties, not 6, because that 6th person is immune to their spouse. Interspousal immunity. The defendant who settled is said to have done so for their proportionate share and cannot seek contribution damages from a co-defendant. So that's an important consideration since most cases settle out of court. Indemnity. The indemnity, like a EE, is held derivatively or vicariously liable for the wrongful act of another. The indemnity was compelled by operation of law to defend himself, but has a right to indemnity to recover contribution from the party at fault, which is a tortfeasor. The indemnity entitles a party to a full reimbursement of suit costs where the defendant is vicariously liable for another's action, but not where the defendants are concurrent defendants. I wrote nothing on that. Contributory negligence from the restatement, section 466, where separate acts of negligence combine to produce directly a single injury. Each tortfeasor is responsible for the entire result, even though his act alone may not have caused it. That's the definition of contributory negligence. So where separate acts of negligence combine to produce directly a single injury, each tortfeasor is responsible for the entire result, even though his act alone may not have caused it. So that's how you would refer to contributory negligence if you're talking about two joint tortfeasors. This isn't talking about claiming that a plaintiff was contributorily negligent. Okay, so comparative negligence. Again, we're talking about a unity principle versus a divisible wrong. So the defendants acted together, and when they do so, comparative negligence may not be applying. But if it is divisible and applicable, in different quantities against, different parties, independent acts, defendants' independent acts brought about the injury or the harm, that would be when comparative negligence applies. In pure comparative negligence, the jury apportions a percentage of the liability to each party. Modified bars recovery if the plaintiff's fault exceeds the defendant's fault, and equipoise is 50-50, so 50% of the liability or more on the plaintiff will bar the plaintiff's recovery. Rescue doctrine. The rescue doctrine allows a injured responder to sue tortfeasors who caused the danger. One, provided that the rescuer did not act rashly or recklessly, and the negligence must exist to he who was in peril. Right, negligence act that imperiled another person, and the peril or appearance thereof was foreseeable to the defendant, and the reasonable prudent person standard is how you would look to determine if the peril was foreseeable from, a negligent act of the defendant, and the rescuer used reasonable care in effectuating a rescue. Exculpatory clauses are like hold harmless agreements. They can only be upheld if they comport to public policy, which means they're unambiguously written. They use the word negligence. They clearly indicate the intent to release the defendant from negligence of the type relevant to the contract. And they cannot be used for intentional torts, and you want to see equal bargaining power between the parties, and the transaction isn't a public necessity. Attractive nuisance is an artificial condition highly dangerous to trespassing children. Landowner's duty. Restatement second, section 342, 339. This is going to be long. I have 3 different things on this note card about the duties imposed on those people who own land. First of all, there's reasonable care to prevent an unreasonable risk of harm, but that would be a known unreasonable risk of harm. And the extent of the responsibility, I just said, is to inspect or to act upon actual knowledge. And the restatement subjects landowners to liability if he has a reason to know about an unsafe condition. A and B. A example is that a duty to exercise reasonable care in the use of land to prevent injury to travelers lawfully using the public highway, take reasonable precautions which depend on the facts and the circumstances of the particular case. B, the duty owed to children who trespass is kind of dependent upon where the premises is located. What is the risk of death or serious bodily injury? Is it difficult to warn children of the risk? And what is the defendant's ability to reduce the risk? Okay, survival statute. Unrelated death does not bar a recovery claim. That's what it's all about. There's a couple different claims that, can be presented that are not barred by death, and that's for personal property, loss of wages, medical expenses, pain and suffering, if expert testimony shows that the decedent was conscious of the pain and the suffering for some time. And however, the survival statute can bar a loss of consortium, intentional infliction of emotional distress, because the emotional distress has ended with that person's life. Defamation, because the person's harmed reputation doesn't exist, or at least the damage thereof doesn't exist anymore after he's dead. The collectability of pecuniary damages is also an action that may be barred by the plaintiff's death. Survival, or the defendant's death. Again, survival is a cause of action for personal injuries, and it survives the death of either the plaintiff or the defendant, or both, which is contrary to common law. An estate can sue for the family, and there's no requirement that the plaintiff had to die from the tort that is being brought against the defendant. So they could have died in a completely unrelated event. Okay. Wrongful death. A cause of action for death of an individual due to tortious act or conduct of the defendant. A cause of action brought on behalf of beneficiaries defined in the statute, or a cause of action can be brought by a personal representative. Wrongful death of children. Okay, wrongful death of children. Wrongful death damages should be for the family's pecuniary interest in the life that was lost, which could be the value of the contributions that that family member was making, and is not generally something that is paid for just society, like a sentimental value of comfort and companionship. I don't know if that's just the common law and it changed or not. Most of these concepts were one time very strict, and the scope was, or the rigidity was reduced. Okay, so the warranty of habitability is another duty upon your average landowner. And in 1979, Wisconsin, in the Pages Dorf v. Safeco case, the common law was abolished, and the court held that if a person lawfully on the premises is injured as a result of the landlord's negligence to maintain the premises, then he, the plaintiff, is entitled to recover from the landlord under the general negligence principles. For example, ordinary care to maintain a premises is placed on the defendant landlord. So in this case, like, plaintiff and his friend are moving in a couch into a house that he's just rented from the defendant, and they're on the second floor, and they're kind of trying to get the couch in by, like, backing it out the door onto the balcony, and the balcony is just, like, so rotted that they put some weight on it and end up falling from the second floor. And we're gonna say that the landlord is responsible for breaching a warranty of habitability. So in this case, I mean, that does impart the duty to inspect on the landlord, where there maybe wasn't one under common law. So, failure to act. Legal obligation to take positive or affirmative steps to effect the rescue of a person who is helpless or is in a situation of peril when the one proceeded against is a master or invitor of an employee or an invitee, or when the injury is resulted from the use of an instrumentality under the exclusive control of the defendant. Such obligation may exist, although the accident or original injury was caused by negligence, a negligent act of the defendant himself or a third party. And failure to warn, which is demonstrated in the Virginia Tech shooting case of Commonwealth versus Peterson, is not a requirement if the defendant had no knowledge of the danger, unless there's so there really isn't an unless, but we'll see. I want to say, if I haven't said it already, right, duty to warn. As a general rule, there is no duty to control the conduct of another, nor to warn those endangered by such conduct, except when the defendant stands in some special relationship to either person whose conduct needs to be controlled or the foreseeable victim. Except there's no duty to warn if the defendant had no knowledge of danger, and that's the case that I just referred to. Okay, so defamation requires a defamatory statement, which tends to expose the plaintiff to distrust, hatred, contempt, or ridicule, and has a serious impact on the reputation of the plaintiff, which can come into conflict with his ability to sell products, or as a tradesman, or even continue getting gratuitous gifts that he or she may have been a recipient of before the defamatory statement. And a defamatory statement additionally needs to be about the claimant, and it needs to be published, and it needs to cause or likely cause serious harm to the claimant's reputation. Publication under defamation is a communication of defamatory words to someone other than a person defamed. This can be spoken in the presence of others, but it must be understood. slander is defamatory statements, which is not permanent, and the key example is spoken word. Gestures can also constitute slander since they are a form of non-permanent communication. Libel is a permanent defamatory statement which can be written, broadcast, or otherwise performed. So public nuisance is a criminal wrong and an act or omission that obstructs, damages, or inconveniences the rights of the community. A private nuisance, on the other hand, is a civil wrong. It is unreasonable, unwarranted, unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion. Negligent infliction of emotional distress is caused by an awareness of negligent infliction of injury to a close relative, the traumatic emotional effect, the emotional distress of the plaintiff, who contemporaneously observed both the event or conduct that causes injury to the close relative and the injury itself. So, put another way, this is demonstrated in two of the cases in our book. We have Thing and LaShuza, and that's where a bright line test comes from. In the bright line test, objective physical injury must be produced by was produced by emotional distress, and the defendant's conduct was unusual and unexpected. The plaintiff is not hypersensitive, and the physical injury is a natural result of the fright. Of the emotional distress is sometimes, can be manifest by, or can fright is a kind of emotional distress. So, in the Daly case, I think, the test is 1, close relation, 2, being an eyewitness, and 3, the emotional distress being a reaction, which is beyond that of disinterested eyewitnesses, and the emotional distress needs to exceed regular grief and not be abnormal to the circumstances. So that might be the bright line test. And what I said before might be the test that came from the case right before it. But because the test before it did require objective physical injury produced by the emotional distress. The defendant's conduct was unusual and unexpected. The plaintiff is not hypersensitive, and the physical injury, I think, is a natural result of fright. Statute of limitations. A cause of action accrues with the infliction of an injury in the minority jurisdictions. But the majority of jurisdictions see the cause of action accruing at the time the plaintiff discovered or should have discovered the negligently inflicted injury rather than the time of the injury. Vicarious liability is the negligence of one party being imputed to another because the relationship, and that can be, for example, respondeat superior, which is let the master answer, like for his servant, or this can apply to employee-employer relationships. An employer's negligence will be imputed to an employee's negligence will be imputed to the employer if the employee is acting within the scope of the employment at the time, and the employer's exercising control over the employee. And the coming and going rule is where this generally does not apply. So that's took us 45 minutes to get through it, all of the new note cards. I'm going to go through some of the old ones that I think are important. Res ipsa loquitur, the thing speaks for itself. Whether there is a factual predicate, sufficient to support an inference that the injury was caused by a failure of the party in control to exercise due care. The maximum recovery rule is that a judge may adjust a jury verdict, if the jury was unfair, by administering a remiture. And a lot of times this is for like compensatory damages, which can include past physical and mental pain, future physical and mental pain, future medical expenses, loss of earnings capacity, and permanent disfigurement, I think. And foreseeability goes hand in hand with proximate cause. The proximate cause extends liability to those whose conduct harms persons within the zone of reasonably foreseeable danger. 5 factors of foreseeability is the character and location of the premises, the purpose of the premises, the probability of injury, the precautions necessary to prevent the injury, and the relationship that the precautions bear to the beneficial use of the premises. A last chance rule is if the defendant's negligence is the cause of the plaintiff's reduction in a loss of chance of survival, then the issue may go to a jury upon a less than normal threshold of proof. If a medical testimony is given showing that the reduction, a significant enough reduction in the chance of the plaintiff's survival. However, damages for the loss of chance does not necessitate a full recovery. Proximate cause is also known as a legal cause and concerns the determination of whether legal liability should be imposed where cause in fact has been established. It is a policy decision made by a legislation or the courts to deny liability for otherwise actionable conduct based on considerations of logic, common sense, policy, precedent, and are more or less inadequately expressed ideas of what justice demands or what is administratively possible and convenient. Damage cannot be remote from the negligence as it could not be reasonably foreseen as a consequence. So cause and effect that cannot be definitely or absolutely proved because it's somewhat remote from the cause is a little removed from the effect. It may have set off like a chain reaction that has several chains, has several links in the chain, and maybe more so than is reasonable to place blame on the defendant. And sometimes liability should be limited to an acceptable degree. And this is the point where the court should stop looking to trace a connection between a cause and effect. Sine qua non is cause and fact, which can be called the producing cause, contributory cause. The burden of proof for this is a preponderance of evidence. This is an inefficient, inciting, or contributing cause that, in the natural consequence, produces incident. There may be greater than one producing cause, which would require that the cause in question must then pass the substantial factor test, proving it to be a concurrent cause. So the substantial factor test is that the cause in question brought about the injury, and without which the cause, that is, without this particular cause, the injury would not have occurred, which is another way of saying it's a but-for test. But for this cause, the effect would not have transpired. And this refers, sine qua non, refers to the cause and effect relationship between the defendant's tortious conduct and the plaintiff's injury or loss. But for test of consequences of an act. The federal rule of evidence brings us the Fry test, which is about the admissibility of scientific expert testimony. It must be valid scientific knowledge derived from the scientific method. The work product must amount to good science, which means it was a published work, it was peer-reviewed. The scientist is an expert in that field. That field is a field that existed before the court, began trying this case. In other words, this research isn't only in existence because of the sole purpose of litigation. The research must also prove to be helpful to a jury, and such ways as demonstrating that the claim caused an injury, or that the claim raises the likelihood of an injury, and that would be the case if the claim more likely than not caused the injury. In California, that means that the chance of injury doubles based on, and that is what needs to be demonstrated before the jury for the scientific research to be admissible in court. Risk utility balancing is from Learned Hand, Judge Learned Hand in the Carroll Towing case. It is a formula showing that the burden is less than the probability of risk times the cost of loss. An excused violation, as it's called in the restatement, section 288, is another way of referring to a refutable presumption. In the restatement, it's defined as an excused violation of a legislative enactment or an administrative regulation is not negligence per se, unless the enactment is construed not to permit such an excuse. And those particular cases are strict liability for child labor and Pure Food Act, Federal Safety Compliance Act, Safe Place Statute, and firearm statutes. Otherwise, a violation is of a legislative enactment or an administrative regulation is excusable if A, the plaintiff was incapacitated, B, and these are just examples, it depends kind of on the legislation or the regulatory or administrative regulation. B could be that the plaintiff was unknowledgeable of the statute, or C could be an emergency that is not of the plaintiff's own making. So, direct evidence is concrete. Circumstantial evidence is for a jury or a court to decide, and res ipsa loquitur is a lack of evidence, but I'm just going to go for it, and oh, no I'm not. I'm going to tell you what res ipsa loquitur is. The mere fact of the accident is evidence of prima facie negligence if 1. It's an unordinary accident that does not normally occur absent negligence, and the instrumentality of the harm was not under exclusive control of the defendant. An example of that is when one motor vehicle is involved in an accident. You generally will say that the driver caused it because there's no real other apparent cause besides his own negligence. Constructive knowledge of a dangerous condition. The plaintiff has the burden to prove that the defendant has actual or constructive knowledge of a dangerous condition on the premises, and 2, the condition posed an unreasonable risk of harm. 3, that the defendant did not exercise reasonable care to reduce or eliminate the risk, and 4, the defendant's failure to use such care approximately caused the injury. Plaintiff's injury. Failure to act in this particular sense is where the negligence of the defendant greatly multiplies the chances of the accident to the plaintiff and is of a character naturally leading to its occurrence. The mere possibility that it might have happened without the negligence right. So this is a case where there's an unlit stairwell without a handrail and the plaintiff fell. And we're saying, was the defendant negligent in that he failed to act or that he failed to have these safety precautions in place? And it is insufficient to break the chain of cause and effect between negligence and injury. So, reading it again, where the negligence, like failure to have these safety precautions in place, greatly multiplied the chances of an accident to the plaintiff, and is of a character naturally leading to its occurrence. The mere possibility that it might have happened without the negligence is insufficient to break the chain of cause and effect between negligence and the injury. I just really don't think that's how that case wound up. I think it was Reynolds, right? Reynolds versus Texas Pack Rye Co. But what I would argue is that, right, I'm not arguing anything right now. A reasonable, prudent person is the defendant is assumed to have knowledge that a reasonably prudent person has. So the defendant is assumed to have knowledge that a reasonably prudent person. And sometimes this is relevant to the time, the place, and the person. So the person could be a doctor, pilot, child, resident assistant, or specialist. The place could be limited by the community rule, and the time could be like at night when it's dark out. A reasonably, prudent person might not be able to see in the dark.